Good evening, everybody. My name is Sam Shihab with the law firm of Shihab Burke, and today we're going to spend 30 minutes this Monday, January 12th, 2026, to discuss dual citizenship. Why is this important? And just to get an understanding, it's been in the news recently, so it's an opportunity to just kind of do a refresher on that. And then we're going to spend some time taking questions and answering them. Any questions regarding U.S. employment or family immigration law. A quick introduction about us. We are an immigration law firm, Shihab Burke. You can contact us at the link below. And if you have any questions, you could uh, e- uh, drop those questions in a website that we own. It's called immigrationquestions.us. Remember, it's .us. In there, you can drop a confidential questions. Obviously, with social media tracking now, people are not comfortable sometimes asking questions. So this is a confidential way to communicate with us. So why are we talking today about dual citizenship? This issue has really have not been a major discussion item until recently. So there is a bill in Congress called the Exclusive Citizenship Act of 2025. That bill in Congress basically wants to make all or nothing citizenship deal in the U.S., meaning that it requires the sole citizenship that you have is that of a U.S. citizenship. Otherwise, you cannot become a citizen. Now, this is not the law. This is a proposed bill. Most experts say that this bill it's not really gonna materialize. We don't know, but it's something that is out there. It got everybody's attention. It's estimated somewhere between 6 to 40% of U.S. citizens are either dual citizens or capable of becoming dual citizen of other country. So that is I think, of an impacting change on the way we do business here in the US. Now, couple of notes so people put things in perspective here. First of all, in the Western Hemisphere, um, Americas, etc., there is really no exclusive citizenship. Any country that has exclusive citizenship that does not exist. However, in Europe, it does exist. Although in the last 20 years, it's been trending towards relaxation. People are getting away from this requirement. Few countries in Europe still have it. I know Germany, Austria, and certain other countries, but all that is kind of migrating towards really more liberal approach and more flexible approach to citizenship. Now, here in the U.S., um, you can become the law today, January 12th, 2026, and for quite some time because this bill may never happen. And if it does, it's going to take a long time for it to happen. And I doubt that it will. But putting a date on this video so people have a time perspective of what we're talking about. Today, to become a U.S. citizen, you do not have to relinquish citizenship in your home country. That's the law today. You're going to pledge allegiance to the United States and to when you become a citizen, but you do not really required legally to relinquish your citizenship. Many known personalities and successful people in the U.S. are dual citizen. Elon Musk, for example, Governor Arnold Schwarzenegger is a dual citizen. George Clooney is a dual citizen, and the list goes on and on and on. So dual citizenship is really on the rise in the U.S. You can become a dual citizen now. It is really the choice of the wealthy. Until recently, Europe was handing them out in some parts of Europe for money. The program in Cyprus for investing or really purchasing a piece of property for $250,000 um, and get a citizenship was something that was available until about 4 or 5 years ago. Um, the Irish Investor Program, which just sunsetted, and as a matter of fact, is a little bit active, requires a donation or requires an investment in in Ireland without, as a matter of fact, being in Ireland. You have to only be in Ireland. You had to be in Ireland for 1 day a year only. That has sunsetted, and it's towards citizenship with a requirement to be in the country. And Spain and Portugal and the list goes on and on and on. Greece, Italy has a program for lineage. If you can trace your lineage to an Italian citizen, um, then you can become an Italian citizen today. And we've done this work. We've worked on the Irish investment program for clients. We've worked on and have gotten approval for U.S. citizens to become Italian citizens, and the other way around. Obviously, we've done that, and we continue to do that. Why do people become dual citizens? Well, flexibility. You really cannot stay a long time if you want to. If you're a retired rich person, you've done well for yourself, and you want to go to Europe, Spain, and spend a long time there. You don't have that. You don't have the visa. You have to buy a property, and once you buy a property, even that is closing because there's been the property value in Spain has gone up so much that they are shutting down that program. But you could have bought a property and could have become a permanent resident and then became a citizen after so many years of living there. Sending school kids for school to school is a big deal. Some kids want to be living and studying in other countries. That's also an attraction. Now, regardless of dual citizenship, today, you as a U.S. citizen, as a permanent resident, required to pay taxes to the U.S. government on your worldwide income, subject to treaties with certain countries and other countries that the U.S. has entered into. So it doesn't matter whether you're living in Spain as a citizen of Spain. Um, or if you're living in Cyprus or Ireland or any other countries in the Caribbean and you obtain citizenship there, but if you're a U.S. citizen, you're subject to taxation. Um, now, obviously, because of the global way people are living, and that's the way people with a better income, obviously, there's a lot of tracking that's going on to make sure that people are paying taxes and complying with the taxation rule. And that's one of the reason, without digressing too much, a lot of the international wealthy people do not want to become a permanent resident and U.S. citizen, but would like to live there. And that's the attraction of the proposed Trump Platinum Card, which proposes to allow foreign national to live in the United States for up to 270 days and not be subject to U.S. taxation. That's a proposal that is nothing in the books yet, but that's the attraction. I have clients who are very well to do overseas who call me all the time. As a matter of fact, I have a call here in half an hour to talk about one of the clients about taking advantage of some of these opportunities, and they're watching it closely. Um, now, um, again, just a reminder, this is a kind of an overview of the dual citizenship rules. So a you can become a U.S. citizen, and you obviously by naturalization, which means you were a citizen of another country before, so you will carry dual citizenship, subject to the previous or the other countries citizenship rules. Some countries, until recently, for example, Germany, this has changed now. You would lose your German citizenship immediately upon becoming a U.S. citizen. That has changed now. You have to get permission, and once you get permission, you can become dual citizen. But you can hold dual citizenship, assuming both countries are in agreement. The U.S. obviously current laws is accepting, and the same most foreign countries are also accommodating, not all. And then you can become dual citizens. Certain countries you have to give up that citizenship, but that's not a U.S. law. That's the other country's legal requirement. You can also become naturalized citizen in another country after you become or after you are a U.S. citizen. If you're a U.S. citizen by birth, you can become an Italian citizen. Like I said, by lineage, that does not affect your your U.S. citizenship. And there was a Supreme Court case on point many years back that said the standard for that requirement, it has to be that you became a citizen of another country, and the other country does not require you to relinquish your citizenship. So the voluntary naturalization, there's no intent to relinquish your citizenship. And even if you do it as a ceremonial, it's a lot of time there's other countries that would say you have to raise your hand and say, I pledge allegiance to X country and only X country. And no others. That's not sufficient to declare you that you have lost your U.S. citizenship. The renunciation of the U.S. citizenship has to be um, with intent, and typically it requires you to go to the U.S. consulate and give up your citizenship there, but not just a ceremonial oath. That's not sufficient to renounce your U.S. citizenship. So that's, and then the State Department presumption is in favor of retaining your citizenship at all time. So this is something that is very important to remember. Now, um, um, also serving in a foreign army in most foreign armies is not sufficient to be declared to have lost your U.S. citizenship. But if you're serving in a foreign army that is in conflict with the U.S., that could trigger that. Um, the last point I want to kind of, and this is really a quick summary, the last point I want to make is that there is a method by which people can renounce their U.S. citizenship, and that is a process. The renunciation process is by statute, and um, you must go to, let's say if you're living abroad, you must go to the consulate, U.S. consulate, uh, and um, go through a process of renunciation, and then you will be declared to have lost your U.S. citizenship. As a matter of fact, I was dealing with an elderly, uh, wonderful guy who is a U.S. permanent resident now, and we're in the process of getting him a U.S. citizenship, who renounced his U.S. citizenship when he was 20 years old. He's like now probably 70 years old, and he had lost it for all that time. And it's of course a long story what had happened to him, but he had to go to to the embassy and renounce it. And the ambassador, he tells me the story that he sent him away, and he said, "What are you doing? This is a life-changing decision you're making." And the young man at the time came back 3 times, and the third time the ambassador said, "Okay, you came here 3 times requesting it. I'm gonna give it to you," and he renounced his citizenship. There's a complex rules and requirement. When you gain your citizenship back, you have to go through the whole process again. You have to qualify for U.S. permanent residency and then citizenship, and also there's a discretion involved. Not only that, but also you may have to account for all the unpaid taxes between the time you lost your citizenship or gave up your citizenship or relinquished to the time you became a citizenship again. This is not like, okay, I made $25 million in 10 years. Let me give up my citizenship and then come back again. No, they want to look at all your assets. They want to look at, make sure that you've paid up all the taxes that due to the government during that period, and then potentially you could get your citizenship back. So bottom line, um, um, single citizenship rule is not unique. This proposed legislation is not unique in the Western in the Western world. Europe had it, but the trend is going towards relaxing that requirement, not bringing it back. The proposed rule today in Congress, the Exclusive Citizenship Act of 2025, all experts says unlikely to pass Congress. And it's unlikely to pass Congress because Congress is incapable of passing any law anyways. When was the last time we saw Congress make any meaningful change, except for the president with a proclamation or the Supreme Court with some decisions? The Congress is sitting there just like a deer in the headlight in this country. They don't make any decisions, unfortunately. So I don't think there is any momentum for this to become law. Today, dual citizenship is available. It happens when you become a naturalized U.S. citizen, carrying your old citizenship subject to the laws of the foreign country that you came from, and then you could become a citizen of another country after becoming a U.S. citizen, so long as you don't, with intent, relinquish your U.S. citizenship. So that's the overview, guys. I hope this is helpful. Um, we switch gears now to answering immigration law questions. A lot of people are patient and want um, get questions answered. Drop your questions in the chat, in the YouTube chat, or in immigrationquestions.us. I will pick them up here and answer them. Um, uh, so there's a question here, and I don't understand it, but let me see if I can show it. Do I need to tune in my turn in, I guess, turn in my passport when I apply for a U.S. passport? I got citizenship my first time. Well, first of all, congratulations for getting your citizenship for the first time. You do not have to turn in your foreign passport to get a U.S. passport. You do not have to turn in your U.S. passport to get another U.S. passport in the future. The process is very straightforward. If you live in a rural area, you can. If you're in Washington D.C., there are agency. You can go there. In many cities in the U.S., the post office is an agent of the U.S. Of the passport office. Typically, is done by an appointment. There's a form you complete. You have to send over. If it's the first time for you doing your passport, you have to send over your um, your naturalization certificate. Now, at the bottom of the naturalization certificates, I don't know if they still have that today. I know for many years they have it. It says unauthorized copying is prohibited. But in my opinion, you can definitely scan it into your secured computer to make sure that you have an image of it before you send the original. They will take the original, they will inspect it, and then they'll send it back to you once they finish, and they will issue the passport after that. So, um, taking questions from immigration questions .us. So I see a couple questions here that came in on the immigration questions.us already, and I'm gonna take them in the order they were received. Or I'll, and by the way, if we don't answer your question here, sometimes questions we don't want to answer them here because they have too many personal details, we'll email you back an answer. So here's a question that I have had from a gentleman. I entered the United States on advanced parole. When CBP officers stamped my passport, they wrote the wrong admit until date, but the I-94 is correct. Do I need to get a stamp fixed? So when you enter an SS on advanced parole, typically they give you 1 year for an advanced parole, I believe, the duration, and then that's it. And you think that beyond 1 year, you're not in status. That really is not the case. You are continue to be a parolee legally present in the U.S. In the period authorized by the U.S. government to be here until your adjustment status green card is adjudicated. So the gentleman may be referring to that scenario, and I don't know whether that's what he means by the wrong date, because um, I'm not sure what exactly he means by that. But if the wrong date is the 1 year date, then that's not wrong date. That's a proper I-94. Now, if you have any concern, or if that you felt that maybe the wrong date was something different, You need to show it to an attorney. The attorney will have to inspect it, and if there's a correction, if there's a CBP error, CBP typically is willing to change to correct that error. But it typically that date that's not matching, for example, your EAD date. The EAD date could be 5 years or could be 4 years, but the advanced parole date on the passport could be 8 months from now. That's not the wrong date. That's how it's normally given, and being in the United States beyond that date is not a violation, and you are in status. All right. The next question I have here is, let's see here. Let me put it in front of me. I have a valid green card EAD. I start using it in case, can I start using it in case my H-1B extension is denied after the expiry of the I-94? Will there be any issue related to unlawful presence, and will be a situation to trigger NTA issuance from USCIS? All right. So, good question. Let's break it up here. So, first of all, a green card EAD is given to you pursuant to an adjustment of status filed, I-485, filed with USCIS, and they give you a green card. And until recently, they were giving them up to 5 years. Now they've reduced it to 18 months. Now, the question is, can I start working on that EAD after my H-1B expires in case I got an H-1B denial? Can I do that? Absolutely, you can. There's absolutely no, as a matter of fact, a significant number of people use that. Now, we would like to keep people extending their H-1Bs um, to the extent possible, to give them the EAD to be kind of more of a secondary security blanket in case the H-1B is denied for whatever reason, give you two options. But there's a lot of reasons why you could relinquish the H-1B and go into an I-94. Right now, especially, the administration is not very happy with the H-1B visa program for whatever reason. They're down on it. They loved it last year. They don't like it this year. So whatever, that's fine. Working on green card EAD is absolutely permissible. It will not trigger unlawful presence. Unlawful presence is time spent beyond the I-94 date without authorization to be in the United States or without legal status, which would render you inadmissible after staying unlawfully for a certain period of time. Unlawful presence is a legal term, and it will not trigger unlawful presence, absolutely not. And it will not trigger NTA. NTA is notice to appear, meaning that being referred to a judge for deportation. It will not trigger that either. All right. Let's see here. Um, Here's a question we got today. My adjustment of status EAD extension has been pending since January 31st, 2025. So that's not too long. So my adjustment status EAD extension. Okay. My recent adjustment status EAD expired on July 15, 2025. All right. I have an automatic EAD extension for up to 500. Now, when the US has approved my pending adjustment as EAD extension, will they approve it for only 18 months from 7/15/2025? More than likely, they will approve it only for 18 months. To be very honest with you, they're no longer approving any EAD for the 5 years. Yes, that's correct. Um, All right. So moving on, we got time for maybe a couple more questions. Um, my current H-1B will expire in July of 2026, in 6 months. After receiving extension next year, if I need to leave the US and re-enter, will I be subject to the $100,000 fee? If the H-1B is extended and you leave, obviously you have to go for stamping, and once you can come back to the United States, and you're not subject to the 100,000 H-1B in that scenario. All right. Um, Another question we have here is, Uh, my I-140 has recently been approved, and my H-1B is up for renewal. So he has an approved I-140, and now he's renewing his H-1B, which is expiring in October of 2026. My spouse is on an H4, but would like to transition to an F1. If we file my H-1B extension, if we file my H-1B extension along with the H4, can I file for an F1 change of status later on? So this guy is, his wife is on H4. He wants to transfer her to an F1 status, and her H4 is expiring. What shall I do? Because obviously she's not ready to. The school hasn't started yet, so the F1 is not ready. So there's going to be a gap between the H4 expiration and the F1 earliest effective date based on the um, the school calendar. So my advice to this gentleman is obviously file an H4 extension, and then when you file for the F1 extension, because the H4 could be still pending, file for an F1 change of status from the pending H4 and reference the H4 that's pending. And typically, it's going to require approval of both of them to get back on F1. In the prior administration, they would adjudicate both of them to get things moving for you. Current administration, we haven't seen much change, but obviously they don't do too much in terms of discretion. All right, let's see here what we got here. I'm trying to get as many questions in as possible. Um, all right, so I got here room for one more question. Let's take that one. Uh, I have an approved advanced parole, but no employment authorization document, no EAD, and entered on advanced parole um, due to not having a stamp on my visa. Can I join my H-1B employer and continue work legally? So this refers to a memo that is almost over 20 years old memo that says that if you come back on enter the United States on advanced parole um, and join the same employer and work for the same employer, if you do not have an EAD, we're not going to consider you to be working without authorization because you joined the same employer on H-1B, and we are going to assume that really you got back on H-1B, and we can extend your H-1B going forward. That memo is, as a matter of fact, I think more than 25 years old. We've relied on it as recent as the prior administration. Um, I would not rely on this memo right now. I would not rely on this memo right now. With the um, uh, policy of zero discretion, this memo, in my opinion, is very risky to follow today. So don't assume that you can enter on advanced parole and take employment and then they're going to treat it as an H-1B. This memo is informal memo. It is more than 2 decades old. There has never been an update on this memo or some kind of a recognition of it beyond the um, the uh, the letter that was drafted 26 years ago, I think, even or even longer. And therefore, in today's culture, I would not be relying on this memo. I hope this give you guys 30 minutes of immigration information. Thanks for listening. Again, if you have any questions, drop them on immigrationquestions.us. If you want to contact us, you can reach us at shihabburke.com, that URL at the bottom. And we'll see you guys 6 o'clock Monday for another session. Have a great rest of the week.